Hi, welcome to SC Seminars. I'm Becky from Library. Today's topic is how to resolve disputes through mediations. So our speaker is coming. Please help yourself. There's some snack over there, and because it's lunchtime, I think if you're hungry, and we will start very soon. Okay. Thanks for coming here. We are very glad to have Professor Leung to give us this talk. Professor Leung is an experienced mediator and arbitrator. He has been involved in a great number of mediation cases related to construction, property, import-export, telecommunication, loan agreement, and shareholders' disputes. Professor Leung is the founding president and governor of the Hong Kong Mediation Center and past president of the Hong Kong Institute of Arbitrators. He is the editor of many publications, including 調解通鑑 2012, Hong Kong Mediation Handbook 2009, China Arbitration Handbook 2011, and HKMC Journal of Mediation. Currently, Professor Leung is adjunct professor of Civil Engineering Department at HKUST. He is teaching a master course on dispute resolution for engineers. He is also the adjunct professor in CTU as well, so very busy. He is also involved in a number of arbitration and mediation organizations in China and overseas. So without further ado, please welcome Professor Leung.
Well, thank you. And I must say that was a very long introduction, but basically I'm an engineer. That's a simple way, but I'm also involved in arbitration and mediation for many years. Okay, so you will get this PowerPoint anyway, so you can read it in due course. I just happen to be involved in many different organizations, and that keeps me very busy. So basically today we want to talk about how mediation will help you in future, in your workplace, in school. Actually, there is something called school mediation, by the way. So I'll go through it fairly quickly because mediation actually is a 40 hours course, and I'm trying to squeeze it in 1.5 hours, and I think that it's quite extensive. So and we'll be talking about what sorts of mediation there is. There's different types of mediation actually, and there are different types of mediation for different types of disputes. And Hong Kong government is very supportive to encourage mediations. One of the main reasons, I think even worldwide, I think people are very different jurisdictions are encouraging using mediation at the moment. One of the main reasons, I think it's very fundamental. As an engineer, I always look at the practicality of issues. And one of the things that I notice is because in many jurisdictions, the court system is overloaded. Very simple, okay? They are overloaded. So people are looking for alternative dispute resolutions. And happens to be mediation is one of the form of alternative dispute resolution. We don't have time to talk about different alternative dispute methods today, but on my last slide, I have one slide to talk about just briefly on arbitration, so you understand the difference between mediation and arbitration. Hopefully after this 1.5 hours, you will learn about that. So there are different forms of mediations, and there are different stages that we go through when we do mediations, and naturally there are different skill sets for the mediators to learn and able to be a good mediators. One of the slides will also shows the selection of mediators, which personally I think is one of the fundamental points. If you select the wrong person, then you get the wrong result, and that's as simple as that. And that will be the quality of mediators. Okay. So I start with what is conflict and what is disputes. Is anyone involved in mediation before or study mediation in the audience? No. Okay, so I have to start from the fundamentals. Okay, so what is conflict? Can somebody tell me what is conflict? Speak up. Let the class hear you. Is that you were saying? What is conflict?
Disagreement.
Disagreement. Sorry?
People disagree with each other or be antagonistic.
So what's the difference between conflict and disputes? How do you distinguish the two?
Maybe more violence.
Violence? That happens. That happens. Actually, conflicts. Are you from the social science department? Yes. That's why. Okay. That's why you come across conflict management, conflict of peoples. Okay. Yes, conflicts is generally for social science. Okay, and generally, when you cannot resolve conflicts, you escalate it into a dispute. Okay, so disputes is action-based. So I'm going to sue you. That's an action-based. The conflict is that I have a difference of opinion with you. That doesn't mean that I'm going to fight with you or violence or whatever reason. So usually conflicts, if you actually there is an exponential growth between conflicts, and it will escalate into the disputes. So that's very good, actually. So we do come across different disputes in our day-to-day life. Okay, I'm just showing some slides here. They could be. Is that a pointer?
Yes.
Oh yeah. Okay. There could be disputes because of monetary. Okay, I buy something in the shop and there's a dispute. We call that consumer disputes. Okay, even you may be fighting with your boyfriend, girlfriends on which channel to watch. Okay, that happens. Okay, so that's why you need two TVs. Okay, and in family we call family mediations. Okay, and quite often in works. You argue because of different opinions, okay? And sometimes it's escalated into violence, and sometimes it doesn't, okay? So there are actually in our day-to-day life, you go and get yourself into a conflict situation, but if you are putting it into action, that will become disputes. The reason of dispute could be varies. Okay, it could be because just because of face. Okay, my opinion is more important than yours. Okay, and you'd be surprised how face come into play in our day-to-day life. Okay, I come across many mediations is because of face. Okay, people just don't want to let down their face and come into a reason, and they put themselves in a position, what we call positioning. Okay, you tend to go into a positioning situation when you have a disagreement or conflicts. Okay, and people can get into pretty violence and they forget about what's their real interest. When I do mediation, I quite often I ask parties to give me a 1-page or 2-page on the issues of dispute, and you'd be surprised how many parties. Quite often that they tells me differently, the 2 pages are different. They could be arguing about the same argument. I came across cases that had been in court for, well, they have submitted the claims in court for 8 years. Some is 2 years, 3 years, okay? And they were arguing about different things. So to a surprise, when people talk, okay, I'm glad that all of you are silenced because at least you're listening to me. Because if you're talking, you will not be listening to me. Okay, so if you so quite often that in communications, people tend not to listen to the other side, especially during when you have a conflict situation with the other side. Okay, they just don't listen, and I'm sure that there's a lot of these situations in our day-to-day life nowadays. Okay. Okay, conflicts, yes, disagreement, okay, over interest, or and generally it's not too long. Okay, you don't have too long a conflict, so it's not really prolonged, but it's fairly conceptual. Okay, but in disputes, claims made between one another. Okay, this is where mediations or any other dispute resolution form or litigation come into play. Okay, and that resulted in real actions. It's more legalistic, it's more positionings, and usually unresolved conflicts will lead to disputes. Interesting, how many lawyers are there in here? Anybody? Any lawyers? I'm glad. Now I can talk about lawyers. Quite often when lawyers involved, they want you to fight. For the simple reason is that that's the training. Okay, when do you go to see a lawyer? When you are in a dispute, okay, you go to see a lawyer. Okay, it's his job to win for you. Okay, so it's adversary. We call it adversary positions. Okay, you tend to fight with each other. Is that I want to kill the other side. Exactly what you said. Okay, I came across a mediation case that I happens to be the mediators, and then we were discussing about the issues, and one side, one of the lawyers suddenly jumped up and slammed on the table and said, "I'm going to take you to court." Take the other side to court because he doesn't agree with what we were talking about. Okay, he wants the fight. Okay, in mediation, one good thing about mediation is parties' determination. That means that the person involved in the dispute make the final decisions. Okay, but since he's representing his client, I'm in the middle of mediation. Naturally, in that case, I said, "Are you sure you want to take him to court? If you are sure you're going to take him to court, in that case, my role is finished. I cannot help you to settle this dispute, to come into a settlement. In that case, thank you very much. I'm still receiving my fees, okay, and you take him to court. Okay, that's your problem. And that will take you 3 years, which is fine with me. And so in that case, I'm happy. Your lawyers, the lawyers are happy because they will receive more fees as a result of that." And so I said, in that case, we finish the mediation. Okay, I have to terminate the mediation because I don't see any possibility that we will settle if you're going to take it to court. Okay, so I walk out the door, I go to the lift. Okay, and as I was going out the lift, waiting for my lift, the lawyer's clients run out and come to me and say that, "Professor Leung, can we continue the mediation?" I said, "What? It is your lawyer that said you want to go to court. So is that what you want?" So he said, "No, that's not what I want. That's what my lawyers want." Okay? I said, "Well, but I terminated mediation, so my term of reference is finished. How can we do this?" Okay? However, I can ask the other side tomorrow. I'll give him a call and see is the other side willing to continue the mediation or not. Then client A, this client was saying that that's fine, that would be great, I appreciate what you do. And I said, okay, in that case, so the next day I called the other side, and the other side said, fine, we can continue the mediation, but with one condition. What do you think? What do you think the condition is? With one condition. What do you think?
Without the lawyers.
Yes, it's quite normal, without a lawyer. So I said, well, fine, if that's the case, if it's without that lawyer, then your lawyer should not be there as well. So at the end, we scheduled another mediation, and the cases were solved in half a day. Okay, so that's a very typical example that I often use, not tradition, but there are even in the mediation sessions, prior or post mediation, different parties, what I'm trying to highlight is different parties have their own interests involved, including your lawyer. He has his own interest involved. And same thing, for you as clients, okay, as parties to a mediation, you also have your own interest. This is where one of the major issues involved in mediation versus other forms of dispute, like resolution of disputes, like litigations or arbitrations. Okay, when you go to court, you tends to submit your writs. I'm going to sue you. Okay, then you have to state your statement of claims indicates what you're claiming the other side. Okay, I had a case that it was involved $40 million. Okay, but at the end it turns out to be $2-3 million. Okay, but the lawyer is so good that he positioned the parties to claim the other side 40 minutes because that's the maximum that he could claim. He has to build up his claim, so he could dream of all the consequential damages, everything, okay, and the delay and everything, and accumulate and escalate the claims into 40 minutes. That was a trading case. Involved a British sole agent versus a manufacturer's, a Hong Kong manufacturer with his plant in China, and with a middle person with a trading company. Okay, and because of defective, it's appliances, so it was defective. So it was shipped to Britain, and then it doesn't work. Okay, so the client, the lawyers is trying to escalate the claims, is saying that, okay, since you shipped this shipment to me as defective, therefore I'm claiming you the whole damages of all the consequential damages to the case. It turns out that that mediation lasted for 3.5 days. Okay, that is the longest mediation I ever done. Okay, it turns out that is who is going to repair the damaged goods. Okay, it turns out to be repaid. If you replace certain parts, then it will work. Okay, who is going to pay for the shipment going back to the factory and replace the damaged part and reship to Britain? This is this manufacturer is one of the largest producer of this particular product. Okay, and the distributors are the largest in the UK. So they both want to work with each other because you can't get anybody else better than these two. Okay, so that it turns out the parties wants to maintain relationship. Okay, in litigation, there's no way you can. If you're claiming somebody $40 million cash, that is, I'm not sure that the manufacturers have $40 million sitting in his bank account or not. Okay, that means that he could go bankrupt as a result of that. Okay, and I'm not sure that he's willing to pay that. And naturally, you have to go through the litigations and all that. It turns out in the 3.5 days, we work out which part that can be replaced. We'll work out who is paying for all the shipment costs and everything, and how long it takes to repair. One of the key things that we resolved, which is beyond the scope of the claims, because the lawyers was only claiming the 40 minutes and nothing else. Okay. One of the key things we resolved is that if you're buying an appliance, is on the shelf of a department store. Okay. So when does the warranty begin? Is it ex-factory, or when you as a user to buy the product from the department store, or it is when, so there's a time lapse. And in any manufacturing conditions, you always have defects. So what is the tolerable limits of defects? Like 3%, 5%, or whatever, okay? These are specific issue if they want to continue their relationship in the future business relationship. It's important to the distributor when the product's warranty begins. Okay, so that was resolved during the mediation. mediations, and actually I still remember at the end of the mediation, when after they signed the settlement agreements, the British agent literally came up and embraced me and said, "Raymond, I'm so happy this was resolved." Okay, and after about a couple months, I ran into the manufacturers in one of the cocktail in Hong Kong, and I asked him, "Are you still working with this agent from the UK?" And he told me that I just had a beer with him in one chai. So that means relationship was maintained. I'm jumping all over the place, but I'm trying to illustrate different scenario to you during the course of my talk. Okay, disputes quite often is because of emotions. Sometimes disputes occur for no reason. I am your boss and I'm telling you what to do, okay? And you're not listening to me, okay? That could cause disputes, okay? So what I'm saying is that you could come across disputes on a daily basis. And actually, I started teaching mediations in '99 till now. And one of the things that really encouraged me to teach mediation is that many of my students, they are not accredited mediators. They don't want to be an accredited mediator, but they find that they could use the mediation skills in their daily life. Okay, and I think that is even more important. Okay, what is mediation? Now I'm getting into the systemized situations. First of all, it is a very flexible process. Namely, there's no rules. No, I think the no rules is the best rule. So I hate to be bound by, even though I'm an engineer, I hate to be bound by all the standards and everything. There's no rules. The rules are set by the parties themselves. You want to do it, I did mediations in a coffee shop, okay? I did it in a very formal conference room, okay? I did it in somebody else's office. I did it in any places, okay? There's no set rules, okay, in mediations. You're getting an impartial third party. Impartial third parties, namely, I have no conflict of interest in the outcome of the mediation. So if you have a disagreement between you two, I'm trying to help you to resolve your disputes, and I have no personal interest other than naturally, if it is a pay scheme, then I get paid for it. Okay. Other than that, I have no interest in the outcome of the mediation. Same as a judge or an arbitrator. He has no personal interest in the outcome of the award or judgment. Okay. Same thing. Same thing. The key thing is the objective of mediation is make sure parties come into a settlement. So if there's a dispute, could be $2 million, it come down to $20,000, there's still no agreement, no settlement. In that case, it's a failed mediation. Okay. The other elements of mediation is confidentiality. Usually, parties will sign an agreement to mediate prior to the mediations. Okay, that means that everything said and done in the mediations will not be taking the material into the future litigations or arbitration or any other place. Anything that's said between the parties is confidential and without privilege. And in mediations, we have what we call joint sessions and caucus or private sessions. Okay, joint session is when two parties talk with the mediators together, and they could exchange views, and naturally the mediators will have to control the situation because, as you said, parties do get pretty violent sometimes. Okay, and sometimes as mediators, I felt that I am the I know the Chinese name, how do I say it in English? 泄氣袋。好啦，其實 somebody tell me 泄氣袋，okay? I air out, okay? I'm the one that is being air out by the parties, okay? And it's interesting that from personal experience that when you get punched by people, I'm the airbag, right? I do get upset. So I normally don't get punched by people, air out by people, but you do get upset. So it's important for the mediators to control his own emotions as well as control the party's emotions. That's why I try to get it. Okay, so in joint sessions, people can get pretty violent because they are upset with each other. I had one case that one of the parties said to me at the beginning of the mediation, he said, "I'm very happy." I said, "Why are you happy? Why don't you start the mediation? Why are you happy?" He said, "My lawyers and his lawyer has been writing to each other for 2 years. Okay, I spent $2 million just writing on letters. Okay, and now finally, that was a trademark case, a real case, a trademark. This company literally took the other company's name, and then he even registered his telephone number, so anybody can call his number, it goes to the other side. So the parties were so upset on this trademark dispute, and they were in court, and they were just about to go to hearing the next week for 15 days of hearing. Okay, and so it cost a lot of money. So, and they fined me on a Thursday. I remember I had a session with him on Friday, and they were settled on Saturday afternoon. Okay, 1.5 days. And then he said, "I'm so happy today." I said, "Why are you so happy?" Because finally, I'm able to see the other side and literally tell you that you actually infringe on my trademarks. You literally are using my company name. I finally can see him, and I say that, say it to his face, okay? And that hasn't even started the mediations. Okay, so in mediation, everything said in caucus or in joint sessions is confidential. Okay, so in private sessions, when parties talk to me, without his consent, I will not disclose it to the other side, and that's very important. And I think it's very important for mediators to earn the trust of the parties in the first 5 minutes of the mediations, because we never met. Okay, I need to earn your trust that I am an expert in mediations in the first 5 minutes, right? Otherwise, you will be walking out. As simple as that. So I think it's important. One of the major difference between mediation, arbitration, litigation, or any other form, and I think it's one of the fundamental of mediation, is parties' determination. The parties can determine your own destiny. You want to go to court with the other side? Go ahead. You want to go to arbitration or adjudication or any other form? Go ahead. Okay. You can walk out the room anytime. You can terminate the mediation anytime, which is very different when you're going to arbitration or litigations. Because in litigations, when you submit the writs to the other side, that's the beginning of a nightmare. The reason is that you are in court for whatever number of years. You can't terminate that unless with the consent of the judge. The judge determined that. Same for arbitrations. Once you start the claims in arbitrations, you cannot terminate unless the agreement of the arbitrators. Actually, you as parties have no role in the arbitration or litigations. Okay, in many cases, you don't even have to be there. Okay, as party, unless you're called as a witness, you're really only giving evidence as a witness in litigation and arbitrations. Okay, and in China, some of you come from China. In China, many parties don't even go to the arbitration or litigations hearing. Okay, you are only called upon as a witness in the whole process. Who determines the progress of the process is hopefully you have a good lawyer, and hopefully you have a good judge. Okay, he or she will determine the progress of the process. But in mediations, you are the one that determines that. Because parties can terminate the mediation anytime. If you don't like it, that's the end of it. You can walk out. The mediators can do that. I was very upset on one of the mediation I did. I wasn't the mediator. I was advising the parties on a mediation case. And the reason I was very upset is that that particular mediator, after hearing the case for the whole day, in the morning and in the afternoon, at 4:30, he said, sorry, I don't think I can handle this mediation. And that he terminates the mediation, and we had to go to arbitration and spend another $2 million. Okay. So mediators can terminate the process. The parties anytime can terminate. Who makes the decision? Is the party, not his lawyer. Okay, I have cases that with parties, lawyers and lawyers together, and I have cases without lawyers. Okay, it is. There was one case that I had to send the lawyers away. So in one of the sessions, the parties indicate that the other side lawyers is ridiculous. I don't want to talk to him. I said, in that case, do you want him to be absent from the mediation? If he is, I can request him to wait in the other room. Okay, so it turns out that two lawyers went into the other room and the party settled in our room. So that do happen. Okay. However, lawyers are important is because they have, especially on complicated cases, is that they could clarify some of the issues for the parties, and their job is to protect the parties' interests. Okay, so in the mediation, actually the lawyer's role changes from adversary, fighting with the other side, I'm trying to claim the maximum to the other side, into advising the parties on what is the best form of settlement. Okay, so their roles are different. Actually, many lawyers doesn't realize that, and I'm sure, actually, with the encouragement of the judiciary and the Department of Justice in Hong Kong now, all lawyer has to learn about this now. Okay, since 2010, there's something called Practice Direction 31 from the judiciary, is that any parties go to see a lawyer, the lawyer have to tell the parties what mediation is all about, and the parties need to sign a form called mediation certificates. Namely, that means that the parties understand what is mediation. That's to start. The second thing is that they are willing or unwilling to go to mediations. I'm talking about civil litigations, not criminal. Okay, all civil litigation cases, the court indicates that unless you have a valid reason not to go into mediations, the judge can impose a cost sanction. That means imposing a penalty, a cost penalty, to the parties who is not willing to go into mediations. Okay, that's under Practice Direction 31. So what are some of the reasons not to go into mediation? If it is an issue involved legal interpretation, that may be. But there are only very few situations that you can really get out of mediations. The cost sanctions means that if you're claiming the other side, if you win the case, normally you get your lawyer's fees and most of your lawyer's fees back from the losing party. But the court can impose that you are not getting your fees back, and that could be substantial. Okay, there have been cases that's $400,000 and legal fees get up to $2 million. Okay, and you're not going to get your $2 million because you're unwilling to go into mediation. So practically speaking, in civil litigation, you have to go through mediation before you go to court. But here, as you said, you can attempt to go to mediation and it fails. Internationally, there's a success rate of about 70–75% of success rate. In Hong Kong, we're a little better because Hong Kong, most of the cases are from construction, now into PI, personal injury, other forms of mediations. Okay, family mediation is a must. You have to go to, on a divorce case, if you file a divorce petition, looking for a divorce petition, you have to go to mediation prior to go to the court for a ruling. Okay, So parties determination is very important. Option generations in mediations is very important that we try to look for options. Not the mediators providing the option to you, it's the parties tend to generate a lot of options. Okay, as I said in my previous example on the trading case, the claim was for $40 million, but it turns out that we're not talking about $40 million. We're talking about how much is to ship back to the manufacturers, and the manufacturers going to replace the product and everything else. So these are options that you cannot discuss in the court of law. And there has been many cases, and many judges also make recommendations to mediation. The reason is that you can go, what they say is that you can go beyond the scope of the litigations. Okay, just like who is paying for the cost of shipping back, and when the warranty begins, what is the percentage of defects allowable in a contract that wasn't stipulated in the original contract. Okay. So we can generate different options. In construction, sometimes, okay, a dispute between the contractors and the client, and so it's not only the claims of the monetary amounts. Sometimes it's the relationship. The contractors wants to bid on future job for the clients. Okay, so that is also works. Realistic solution. Why I say realistic solution is that who knows the dispute better than the parties? Not his lawyer. It's the parties themselves. They have been involved in the dispute throughout, and they want to resolve the dispute. So the solution must be realistic. That means it's acceptable to the other side. Okay. I had a case on claims. I act as a mediator. The claim was $2 million. If I was the arbitrator, I would have awarded $1.8 million to one side. Okay, because he has genuine grounds. Okay, after I hearing the case. The settlement was $400,000, so which is way below what it was deserved from a normal person. If I'm a judge, I'd probably give him $1.8 million. Okay, but the parties accept $400,000. It's not up to the mediators to decide that is correct or right or wrong, as long as there's a settlement, because our objective is to achieve the settlement. Okay. So the case was settled. After a couple of months, I ran into the person that accepts $400,000, and I was wondering why. You know, I said, "Hey, why you accept $400,000? Now we can talk about it. You know, it's all settled, everything." Okay. He said, "Well, first of all, I'm getting paid within 7 days. Okay, I'm not sure his company is going to be around in the next 2 years or not. Okay, he could relocate his asset and change his name or whatever. Okay, so I want to get paid tomorrow." Okay, that was his objective. It wasn't told to the other side. He never told this to his lawyer, definitely, but that was his decisions, parties' determinations. Okay, I'm sure his lawyers advised him not to accept the $400,000, but he did, and he kept paying. He said, "It's better for me to move on in my life to go to do my business. Okay, I probably make more from doing the business rather than spending the managerial time in fighting the case here, and which I'm not sure I'm going to 100% win, and I probably have to pay my lawyers $2 million. Okay, that's the cost involved. Okay, so that was his reason. So at least he can have $400,000 right away, and he doesn't want the aggravations or the worries of the case itself. Okay, maintain relationships. I think I talked enough about that. I have 14 slides, and this is only 7. So anyway, okay. There are different types of mediations. Okay, facilitative is generally, as I said, the mediator does not get involved in any judgmental. It's helping the parties to settle. Okay, it's quite often used in commercial. Workplace. Okay, transformative mediations is usually there's an extreme power difference, like the parents and the son. Okay, family. okay, disputes, okay, there's a substantial difference, or the university and the students, or a big developer and the small contractors, okay? So what we call transformative mediations, okay, I won't be getting involved in that, the details. Settlement oriented mediation, settlement mediations, is there's a dispute, pretty straightforward. Construction cases can get very complicated when you have 300 claims involved. It can get pretty complicated, okay? But the objective is to come into a settlement. Okay? Evaluative, we're talking about evaluative, and actually the government is, had already set up a committee on evaluative mediations. The objective is how Hong Kong can use evaluative mediations in different sectors. Okay, one of the major sectors is the intellectual properties, because you do need experience in intellectual properties. Like you need to be an expert in the area to give an opinion. Okay, an opinion. However, it is still mediation. That means that parties can still determine the outcome of this mediations. Okay, narrative mediation is a victim offender. For example, a prisoner in jail, a young person that he has stolen something from a shop, and even though he served his sentence, but still, if he walks back into the shop, I don't think the shopkeepers welcome his presence. So narrative mediations try to help the shopkeeper and the offender to come into terms with each other. And actually Hong Kong is doing quite well in this area. Peer mediations is that we have started in high schools on using mediation. These are more senior youngster acting as mediators. We train them as mediators to help younger child when they have fights in school or whatever. They get more senior students to help them to settle. Okay. And actually, even in school, I'm not sure in HKUST, I did some drafting for Chinese U, and actually they use mediation as part of their grievance resolution in the school. Like for example, between the staff and the departments have a dispute, or a staff and the student have a dispute, under the grievance procedure they do have mediations. I don't know about HKUST. Okay, these are just some application of mediations. You can just read them. I touch onto it. International borders, actually under the United Nations, they do have a conciliation group. The conciliation group is to help countries to settle disputes on their borders and any international dispute. One of the classic examples is the Camp David Accord, which President Carter acted as a mediator to help to avoid the war between Israel and Egypt previously. Okay, I'm just, okay, I have everything out so that I can go through it more quickly. Okay, the mediator's, one of the mediator's role is to make sure that parties, naturally the mediators want the parties to come to a settlement. But the settlement agreement has to be fair, okay? Otherwise, people don't want to enforce it. So far, I haven't heard of any settlement agreement that parties do not willing to honor it, okay? There's no such cases anywhere, okay, that I know of so far, okay? However, a settlement agreement actually is a contract, So if there's a dispute, the settlement agreement will be taken to court for enforcement. So, however, as a mediator, I think it's important for the mediator to make sure that the contract, namely settlement agreement, is a good contract that can be enforceable. Otherwise, people are wasting time to come to mediation, isn't it? Quite often, I felt that it's making the impossible comes true. I have cases that party will say that this is my last offer. This is my last offer. 8 times. 8 times, literally. Okay. I just did one. I lost count of how many times he said, this is my final offer. Okay, I just did one. which is beauty parlor versus one of their clients. Okay. But they said this is the final offer. I lost track of how many times they said this is the last offer. So there's no such thing as last offer. I find that when people are coming to settlement, but there are skills that trying to make people come to settlements. Okay, sometimes you call it tossing the coin. Right? You toss a coin and see who wins. Okay, sometimes you split it or whatever. Okay, there are different techniques. Okay, emotions. You're absolutely right. People get very violent. Okay, I did construction case. People are very violent. Okay, but it's up to the mediator to control their emotions. Well, how we do that is we separate them when needed, okay? And people do come to their senses. After they air out, they do come to their senses, okay? But it's important to control parties' emotions, especially in joint sessions, okay? The objective of mediation is to build up communication between parties, okay? It's important to build up the communications. People tend not to talk to each other, okay? I don't want to talk to you. Okay, I will take you to court, and they don't talk to each other. Okay, without communication, you will not resolve any disputes. Okay, options we talk about. Reality, we have something called reality checks. That means that we want to make sure that the proposal on settlement is practically workable. So we use reality checks and enforceability. Enforceable meaning that we want the settlement agreement to be enforceable in future in whatever law involved. I did cross-border cases that it was a Japanese bank versus a Malaysian borrower with a Singapore regional office and Hong Kong branch office. Okay, and it was first of all, we want to make sure that once the settlement agreement is done, which law is going to apply? Hong Kong, Malaysia, which is very different. Okay, Malaysian law involves Islam law. So when cross-border disputes, you have to be a bit careful. Okay, on this. So as a mediator, you should make sure that the agreement is enforceable. Even with a JV between China and Hong Kong, is it using the Chinese law or Hong Kong law? Very different. Okay, how the enforcement is being done. Oops, too fast. There, okay. Trust and confidence. I said the first 2 to 5 minutes. I need to earn the trust, okay? You have to felt the mediators to be neutral. You know, one of the ground rules I tell the parties is that during the course of mediation, quite often you felt that I'm helping the other side. But in reality, I'm not helping the other side. Okay, I can tell you that right now before we start. Okay, and I did have cases that party will say that, are you helping the other side to try to get me to settle? So I start out with my ground rules and tell them that I'm even-handed. Okay, no personal views. At times, the party will ask you, Mr. Mediator, what do you think of this? You know, after a whole day of discussion, what do you think? How should we settle? Okay, in facilitating, I'm talking about facilitating mediations. I don't give opinion. I don't give legal opinion. If you want legal opinion, you can ask a lawyer. You are free to ask for legal opinion at any time during the course of the mediations. Okay. However, is it true that I'm totally impartial? Do you think a judge is impartial? Put up your hands if you think a judge is impartial. Okay. Or a jury. You think a jury is impartial? How many think that they are? Anybody? So you all think that he's not, right? Any objections? I have no opinion. Okay. I'll give you just some statistics. Okay. There's a studies in the U.S. that interview judges and juries when they make decisions. No judges are impartial. Nobody is impartial. Because if you hear the case, then you have to form certain opinion. before you give a judgment or an award. Otherwise, how can you make a judgment? How can I say that you win the case if I don't have an opinion? Okay? So that word is actually fictitious or philosophical. Okay? Impartial. Okay? Well, naturally, I do have certain opinion at times when I'm doing mediations. It's how you present it to the parties is important. It's the parties felt that you are impartial. That is more important, isn't it? It's an opinion. How you think that person, if you think that person is good, that is good. You know, it's how you think. And this is why in the court of law, they say that procedural impartiality. You have to follow the proper procedures. That's what it is. Okay. Okay. So no personal views. Confidentiality is very important, so that people will trust you because they felt that you keep silence on matters that should be kept. Okay. Okay. Okay, as I said earlier, it is quite often people discuss about different conflicts. Okay, they thought they are talking about the same conflict. It turns out that they are different. Okay, in mediations we focus on parties' needs. Okay, and interest-based. Interest-based. What's your real interest? What's your hidden agenda? Okay. Even though the example I gave, the lawyers was claiming 40 million, but the real hidden agenda of the parties was to maintain business relationship, getting resolve the problem that will occur, which is the appliance didn't work. Okay, so those were not presented in the court of law. Okay, so parties' needs. Okay, and exchange of information is very important. The case that I gave you an example is that I was advising the parties is that we're very upset. The reason is that we haven't even started exchanging information between the two parties. Then the mediators say, I surrender. Okay. Actually, there was another study that was done that it turns out that, as I said earlier, 75% to 8% success rate for mediations. Okay. In China, I taught the intermediate court judges before they studied the course, their success rate is about 35%. After they studied the course, it went up to about 67%. Okay, that was a report that was written. And actually, on the result of the mediation, even the failed mediations, the party satisfaction rates, meaning that how parties look at mediations, went up to about 90-odd%, even though it doesn't settle. Because there was a lot of misunderstanding or a lot of disagreement, it might be clarified during the mediation process, even though they have to go back to court or they have to go to the arbitrations. Okay, at least a lot of exchange of information is done during the mediation. Therefore, it will cost a lot less in future. Okay, clarified issues, and as I said, the example I have 2 pages. It turns out they are different. We need to clarify what are the issues in dispute. Communication we talk about. Okay, positioning we talk about in litigations, arbitrations, positioning. Naturally, your lawyers will position yourself how you fight the case best. Okay, here we're not talking about all that. Okay, I had another case that I remember there's 7 lawyers on each side. There's a barrister, there's a solicitors on one side, and that the barrister, when it started, he stand up just like in court, having a stand, and he said, I'm prepared to present the case. Then I stopped him right there. I said, he was going to argue about the point of law. I said, first of all, we're in the mediations. We're not here to talk about point of law. If we're going to talk about point of law, you should be in court. You should not be here. Okay. So he sat down, okay, And he's a very expensive barrister. He costs $8,000 an hour, I know. Okay? And he was sitting there for half a day doing nothing, basically. Okay? But he's still getting paid. Positioning. So, oops. Okay. So people get very positioning at times. Okay. It's up to the mediator to control the situations. Okay. Identify common grounds. There are always common grounds. Okay. Point of interest. What's the objective? And people get too involved and they get too emotional. So you have to separate what's the problem. Is that really related to you or not? Okay. Empowering the parties, as I said, there's different power positioning of each parties, and we have to try to level off as a mediators by different techniques. For example, if I come across here, I talk to you like this, which is he won't fall asleep, you know, because if I talk to him like this, right? If I stand in the middle of a room, nobody will fall asleep. But if I stand here and I keep talking, people will tend to fall asleep, isn't it? Okay, there's difference. So I want to give him more power in the mediations. I will be talking to him much closer or leaning forwards, okay? And there's something called territorial, okay? I couldn't talk to you like this, right? You felt infringed. So these are techniques that we use from time to time, okay? We don't impose pressure on settlement. However, we do highlight that in the event that you don't settle, what are you going to do, okay? Do you know how much it costs for you to go into the next process? For example, litigations? To your surprise, many parties don't realize how much it will cost them. I said, well, if you don't know, then why don't you ask your lawyer? Right? So you go and call his lawyer and find out, oh, it costs $2 million. Fine, okay, I come back to settle, okay? So there are different techniques that we can use, okay? However, reality, I'm talking about even though you go to the next process, that's reality, isn't it? Okay, if you don't settle here, then you better think about something else. Okay. Okay. Why I talk about quality of mediators? Because it's important, because most of you will be parties in life, okay? Not as a mediator. So if you need to choose a mediators, then I think it needs to be that the person never give up. I think that's very important, okay? It has to be positive. And actually, one of the major roles of the mediators is to control the process. When you should be in a joint session talking with the other side, when you should be separated, as the ladies here said that, okay, if the parties get too emotional, you have to separate the parties, okay? And preparation is important, even as parties, because if you don't prepare what you are going to talk about, you don't just expect to walk into a place and come into a settlement. You have to know your bottom line. Even if your bottom line can move, okay, as I give you the example, the final offer can move, okay, everybody can move, okay, but you still need to know the basis of the case. You have to prepare the case, you have to understand the situation. Are you first-hand information, or it was reported by one of your staff or something, okay, so that is important. I always think that I'm a nice person, so I think I'm qualified, so stages, okay? How much time do I have? I still have half an hour, good. Good. Okay, I'm just have it go out, okay? Normally it's go one at a time, but now today, with half an hour, I'm in 17, so I'm pretty okay. Okay, normally we have opening statements, okay, as mediators I would say that what are some of the ground rules needs to be followed by the parties, like you don't yell at each other, Okay, you don't swear at each other. You turn off your phone into silent mode. Okay, when the other side try to talk, let him talk. I will give you opportunity to talk when the time comes. Okay, when your turn comes. Okay, and then the parties will present the case. Quite often, their lawyers will start to talk about the history of the case and all that. Actually, I don't even want to hear about the history of the case. Okay, that's not my problem. The history of the case, who knows best the history of the case is the parties themselves. They already know. Why do you have to say it again? And sometimes I do allow them to talk a little. The reason is that I realize that they are charged by the hours anyway. They will have the statements. They will be yelling at each other and say that I'm right, you're wrong. That's quite often the case. Okay. Then I will try to reframe, what we call reframing. Use reframing technique. It's a technique that we use. That is, when you are saying something bad, I want to reframe it in such a way that the other side don't feel that bad. Maybe that's a good way of saying it. Okay. So the other side normally is yelling at each other. So I say, okay, we hear you. Okay, you have air out. Okay, and now the major difference is this. So you're really laying out the grounds, the agenda for the mediations. Okay, then usually this is held in the first joint sessions, namely the two parties sitting together. So after the presentations, then at a certain stage, then mediators will instruct the parties to go separate ways, and then talk to one side before the other. And that is the first separate session or caucus that we set. From time to time, there are issues that when the mediators felt that parties should be sitting together to discuss further. For example, on the trading case, that because which part needs to be replaced and which part not to be replaced on that particular appliances. So the two sides would know best. I have no clue in that industry. I'm not even in that industry at all. I don't know how to make this electrical appliance. Okay, even up to now, I don't know how to make electrical appliances. Okay, that's not my profession. Okay, it's up to the engineers to really talk about which parts need to be replaced, which part not to be replaced. Right? They are the expert in the field. Okay, so this is when I will have subsequent joint sessions when needed. Okay, actually, this not only applies to technical, sometimes even on settlement or deadlocks, what we call deadlocks. Okay, both sides don't want to settle at a particular deadlock. And you put them together and say, "You sure you don't want to settle? Think about it twice." Okay, you're facing the other side now, because when he's talking to me in a caucus, it may be different as compared to talking with each other in a joint session. Parties tend to behave differently. So you might put them into a joint sessions once again, and then you separate them out to work out the solutions. So that happens, okay? At times, quite often, at times I thought, oh, there's no chance for them to settle, okay? I put them together, and then I separate them back again, then it works. The whole thing keep rolling, okay? And sometimes there are offers from one side, the other side doesn't have an offer, and the other side may felt that he needs to give an offer, okay, to the other side. Okay. So finally, after a number of rounds, depends on the complexities and the parties' responses. Okay, I find that on smaller cases, parties tend to go more rounds than larger cases. Okay, the reason is that I think the parties tends to know the case a lot better in large cases. They do their homework, okay? Rather than individuals tend to have more rounds, okay? And then finally, we will have an agreement. The agreement is called a settlement agreement. As I said, it can be enforceable by contracts. Once it's signed, then that's the end of the mediations. I'm no longer the mediators. I'm no longer involved. And quite often at the beginning of the mediation, I tell the parties, whatever notes that I wrote down, it will be destroyed because of the confidentiality issues, okay? And you cannot subpoena me to future proceedings. In some situation of the settlement agreement actually is drafted in a form of an offer. The reason is that, for example, with involved in government disputes, governments may need to go back to the finance branch to get money and things like that. So the offer will be drafted as an offer with an expiry of, let's say, 7 days or whatever. Just like the bank, the Tokyo Bank, that case that I did, the settlement agreement actually was drafted as an offer with 7 days allowable for the Tokyo branch headquarters to get the approval before the execution of the settlement agreement. So it's not, sometimes it's not strictly just an agreement, but an offer with an expiry. So you don't call people by names, okay? During these are just ground rules. I will highlight confidentialities, and the parties are decision makers, and actually you can terminate, and the process itself is voluntary. Without the other side's consent, you cannot go into mediations. Oh, one of the things that I have not mentioned is that checking authority who settles. This is sometimes if you're representing a company, are you in authority to make decisions in the mediation? That is important. So quite often that I have a letter of authorization from the parties to indicate, if it is not an individual, to indicate that they are in a position to settle and attending the mediations. I had one case that parties request that all parties sitting in the room needs to sign the agreement. The reason is that he does not want anybody in the room after they go out to talk to somebody else on the issues. Okay, confidentiality was one of the, because there was a very publicized case, so they don't want anybody to talk about it, including their own staff and other sides, because in that particular case there are district councillors there as well, so they don't want the district councillor to walk out the room and then start talking to the press and talk about the case at all. So everybody has to sign the confidentiality agreement in that particular case. Okay. Okay, I talk about notes keeping will be destroyed. Skills, okay? Initially, when we begin the mediations, quite often this was the situations. What we're trying to do is that we're trying to bring the two together, and naturally in the middle here, these are the common grounds that we talk about, okay? Common grounds. And what are the mutual interests? What's your mutual interest? Like the example of the trading is that they still want to do the business with each other. They want to have they still want the supplier to supply these electrical appliances to them in future. Okay? Common interest. I still want to do business with you in future. Okay. In the workplace, okay, you're a colleague of mine. I still have to see you every day because you're sitting next to me. Okay. Okay, this is communications. Sometimes why we need a third parties. Okay, in normal disputes, normally the two parties will start talking with each other first. They fail, and that's why they need the third party. Okay. Okay, I will talk about this. Okay, communication. This is very important. It turns out there are two things. One is called verbal, one is called nonverbal. Okay. Turns out that after you walk out of this room, you probably only remember what Professor Leung may look like. Okay, and probably remember how I talked to him, okay? And not much about mediations, because you only hear about 38% of the verbal. And you remember the gesture that I showed you, how I talk to you, okay? That's not verbal, right? I don't turn my back to you, because in that case, I will notice that you fall asleep or not, okay? By refacing you, okay? These are the non-verbal components. The content of the material, you can read it in the in the website in due course, and that only constitute 7% of what you hear. Okay, so the majority in communication skills is basically the nonverbal. Okay, and how much you remember what long hair said in lecture? Probably not much. You remember his face and his gesture, he throws things, right? That's all. That's all. Okay, that's non-verbal. That's non-verbal. That's a good example. So in mediations, we try to use the basic communication skills. Very simple. I talk to you directly. Okay, simple, straightforward. Okay, no flowery language is necessary. Okay, very specific. How you resolve things. Okay, as I said earlier, giving you the example of empowerment to the other side. Maybe during caucus, I will be sitting closer to the people in rather than sitting very impartially during the joint sessions, because I don't want the other side to feel that I'm trying to help one side, right? Attendance is very important. Am I listening to you? Okay, people want to feel that I'm listening to them, so that I gain my trust with the person. Sometimes silence is good, okay? When there's a deadlock, I purposely don't want to say anything. Doesn't work. Right? How come? What is he doing? Right? Then you start to wonder why he's not saying anything. Right? You'd be surprised how silence work. Okay? Not necessarily only speech, behavior. As a mediators, parties are looking at my behavior. I had one case during one of the caucus. The party said, Raymond, I really felt that you want me to settle. Actually, two cases. Okay. The party said to me, I really felt that you really want me to settle. Yeah, I said, sure. So obvious that you should settle. Okay, the claims is $400,000 and you're spending $2 million to get the 400,000. It's ridiculous, right? So from my behavior during the mediations, they felt that what they should be doing. So there are certain guidance throughout. Okay. Well, paraphrasing. As I said, we use reframing techniques to help parties to calm down. We use reframing techniques to summarize. We always summarize because when people talk, sometimes they're not quite sure what they talk about. Okay, you have to summarize for that, because what I hear may be different. Like if it is an offer from one side, then you speak your offer, that may not be what you meant. Okay, so very often that I try to summarize the offer to the party and say, this is what you just said. Is that correct? If it is, then fine. Then do I have permission to use this to the other side? Remember confidentiality, I need to keep the confidentiality of the parties. So I need the consent of the parties to give me to speak to the other side, right? So I summarize the issues, okay, and then naturally present it to the other side. There are different questioning techniques that we use. Is that what we call is some are open questions. What do you think of this? This is an open question. Should you be doing this? That's a closed question, isn't it? Should you be doing this? Is that? So your answer is either yes or no. Okay. Yes, I should be doing this. No, I should not be doing this, right? So that's a closed-end question. Open question, what do you think of this? Okay. If this is the case, would this be the situation? Okay. So there are different techniques in mediation that we use to, we're not leading the parties into a decision. The decisions comes from the parties. Options come from the parties. But we do have different scales of questionings. Naturally, active listening is important. People want the other side to listen. Okay, quite often parties don't want to listen to the other side, especially when they have a dispute. Okay, and you have to force yourself to listen. Okay, and you're creating an environment for the other side to listen to the other side, and this is why in the ground rules I said when one side is saying, speaking, let the other side get a chance to speak. And so actually that imposes listening to the other side, isn't it? So. Well, in the Chinese word, listening is obviously you have the ears and you have the heart to listen. If you don't have the heart or the ears to listen, you don't listen, basically. Body language, facial language, eye contact. If I'm looking at you, eye to eye, you know I'm looking at you, right? There's no question about it, okay? I demonstrate the technique of leaning forward. Open gesture, okay? If I'm talking to you like this, do you feel comfortable? Okay? Or you rather me talking to you like this? Okay? There's difference, okay? And we do look into these techniques quite in depth, even especially during mediations, okay? Come on, you should be looking at this, okay? You should be looking at a different angle. What other angles do you think you have? Reframing, I talked about that. So we're trying to create even something negative into a positive or into the right direction of a settlement agreement. See? Settlement agreement. So we changed the context of what you said and into something meaningful, okay? We try not to talk about the past because there's a lot of grievances. Generally, there are a lot of grievances in the past, okay? And we focus on future. What are you going to do next? How are you going to do this next, okay? From negative to positive, okay? And then we talk about positioning into interest. Hostility, people can get very hostile and then change it into natural languages. So once we bring the negative self-focus, what's best for you into common interest, constructive, into resolution, conflicts into resolutions, and you can have some kind of negotiation, and hopefully you get to a settlement. Knocking, I wrote a book on Asian mediation. It turns out that knocking to some cultures is accepting, okay? Acceptance to some cultures is not. If you talk to a Japanese, he always knock. Does he mean that he accepts what you said? No. So different cultures do have different meanings in body language. Okay, there are cultural differences. Okay. Mirroring, the reflecting skills, meaning that if you are behaving this way, do you think the other side will accept? If you were him, will you be accepting this particular behavior? That's mirroring. Okay. Oops. Okay. Leading skills is that yes, we do lead. As I said, even judges or juries are not impartial. We do lead in a way, but we use reframing to reframe it in such a way that it comes from the parties. Okay, just enough to keep the mediation process moving. Okay, and summary table sometimes is a tool that we use. Why not? These are probing questions. 夠鐘係咪？10分鐘。啊？哦，10分鐘。Oops. Okay. Done. Conflict. Okay, you can read this. Deadlocks from each side. Crossing the last line. Quite often I find that on a large dispute, it comes to the last hall. That could take as much time as bringing the dispute into reality. Okay, people, because of face, because of different reasons, because of interest, because of approval limits or whatever, okay, they don't come into terms. And as I said, a failed mediation means that you don't, even with $1 difference or one thing that is outstanding, that is still a failed mediation. Okay, so there are different techniques of doing it, like splitting the difference, make the last offer. Even though when I say last offer, that doesn't mean it's the real last offer. Or you can cool down the people, cool down the parties, or you separate them out into their own respective rooms, so that they could be calmed down and come into their senses. Okay, even the last part, I have given in $1.5 million already. Why should I give in the last 100,000? That's quite. I hear that's quite often. Okay, I have discounted my offer substantially already. Why don't I just? Why do I still have to give it? Okay, I'm not going to give it. Okay, this is quite often the case. Okay, so you need to calm them down. I had one case that on the last gap that this company had two brothers. One brother say yes, the other brother say no. But still, he's one side of the parties. So I have to do a mediation within the mediation. That means that I have to settle the differences between the brothers before they can walk back into the room and settle the matters. So it was 6 o'clock in the evening that day. And I said, finally, why don't you go home and you two fight it out, okay? And come back in the morning, okay? And hopefully we settle. Next morning, they come back with a draft settlement agreement. So they did fight it out, okay? So, see, one of the cases, because that particular case was involved with 8 years already. And finally, one of the brothers said that, forget it, that's the end of this case. I don't want to fight anymore, Okay, and why I say shaming the parties is that you tend to say that, hey, come on, the other side gave you an offer. Are you going to give an offer or not? No, I'm just going to stay at where I am. But the other side actually give you an offer. Okay, how do you respond to that? So in a way, it puts him in a position that he has to give an offer. Okay, so that's called shaming the parties. Okay, options. Okay, this is something I just want to touch on too. 2 more slides. Okay, Arbitration is also neutral, impartial, okay, subject to procedural law. It is following the court procedure. So the court procedure will rule you have to sworn under oath. I always say in mediation, I don't know the parties are lying to me or not, which is not important because you cannot lie to the other side. The settlement agreements is a party determination that the parties will know that you're lying to them or not. So it's not up to me to decide that parties lying to me or not. And as a matter of fact, there was one case I purposely didn't want to settle because it was referred by the High Court. During the process of the mediation, I felt there's some illegal activities going on. I wanted to go back to court. So that was easy. So I just said, are you going to settle or not? If you're not going to settle, then fine. Thank you very much. Let's go. Okay. So there are cases like that. But here in arbitrations, you have to sworn under oath. The procedure is a lot more formal. It is similar to court proceeding, and naturally, lawyers will present cases and relevant law for arbitrator to make a decision. The only thing the parties can do is that you are in the position to select your arbitrators. That means that in court, you cannot select the judge. The government will say that which judge will take care of your case. Okay, it's not you that decide who is the judge. But in arbitration, you can decide who you want to be the arbitrators. And Hong Kong is very supportive to arbitrations. I myself is also an arbitrator. Okay, so and in terms of appeal, it's very difficult to appeal an arbitral award. Practically speaking, the only condition that you can appeal an award is that when there are fraud on the part of the arbitrators. Okay. And arbitration awards are enforceable throughout the world, over 200 odd countries. There are different agreements signed. Okay, precedent case and law facts are important. It is adversary because just like you are fighting in court, that the lawyers is trying to fight the other side. As simple as that. So it's adversary manner, which in mediation is not. Very limited appeal, enforceable internationally. Okay. Okay. And you can choose somebody in the particular field that you feel is competent, so that a lot of customary slogans does not need to explain to the arbitrators. For example, if it's a construction case, you choose somebody in a construction field, so a lot of terminology you don't have to explain. So the specialists can be chosen as arbitrators. Conclusions, okay, mediation is an art, it's not a science. Even though you can take a mediation course, that doesn't mean that you can practice mediation effectively. I think it's an art of communications. Okay, you must learn it with practice. You learn it from interaction with people, sharing just like sessions like this. We do have experience sharing sessions with students. I think one of the most important things for mediators is that he has to have hearts. I think that's something that if you want to be good at something, you need to have heart. Simple as that. Thank you.
Thank you very much for Professor Leung's non-stop 1.5 hours workshops. So let's Professor Leung have some water, and if you have some questions, please feel free to raise, because it's already 2 p.m. If you still have time, you can stay for Q&A sections, or otherwise you may need to leave for others your class. So any questions so far? Immediate questions?
That was easy to let me go.
Okay. Any questions?
Oh, you can send me an email if you have questions.
Yeah.
Yeah.
Okay. But I have questions that what's the key characteristics for as a successful mediator? Do you think is the key important characteristic?
You have to have heart.
Oh, okay, so it's hard to say. Okay.
Okay, thank you.
Okay, there's a question there.
Just my curiosity, what you said your engineering background, so what made you to switch to this field? It must be some turning point and a strong motivation.
I was involved in arbitrations many years ago, in 84. And I started the Hong Kong Mediation Center. And I felt that mediation is something that is good for people to maintain peace and prosperity. I felt that is a much better way, and it's more suited for the Chinese culture or our culture in Hong Kong to progress in this area. It turns out that subsequently many countries do move into mediations. As I said, one of the reasons that the court is just so fully loaded, and you have to wait for 3 years, 2 years to get a trial. And there were a lot more issues that cannot be resolved by the court themselves, which many judges do agree with me now, that a lot of people thought that everything can be resolved by the court system, but it turns out not. So as I said in my talk, that a lot of issues can be resolved beyond the scope of the court, okay? And that makes mediation much better, in my personal view. Okay. Surely, it's a lot harder work to become a mediator than an arbitrator or a judge. Because if I'm a judge and an arbitrator, I do arbitration as well. I just sit there and I listen to the two sides present their case, okay? And then I make my judgment based on that, okay? Which side I want to believe, then I just make my judgment. But for mediators, I have to work constantly. I have to work throughout the whole mediation process. I cannot stop. When I'm talking to you, I have to think. When I'm talking to the other side, I have to think. When you are together, I have to think. It's a non-stop process. Actually, doing a mediation work is a lot harder. I get a lot tired after a day in doing mediations than arbitration. I can fall asleep. It's not up to you. In arbitration, if I fall asleep, so what? You keep presenting. So.
Thank you for your speech. Was very interesting. How can be sure the side that you are like a judge do not take the position of one side or another side? I think maybe people believe the judge can make a decision. How to say? It's impossible to have a deal previously with the judge, for example. And
are you sure?
Just use the law. But, for example, one side can come to you as a mediator previously and maybe ask you to help them. And how can the other side be sure that you are like a judge? Do you have?
How can parties be sure that I'm impartial?
Yes. Yes.
I think there are 15,000 lawyers in Hong Kong. Which one you choose?
Difficult.
Mostly by referral and by reference. So your reputation is important, isn't it?
Yes, you're right.
Okay? So this is an example I give, is that if you have a case, you have to find a lawyer. Oh, the 15,000, why you choose this particular one?
Maybe use the advice of my friends or my company. I prefer a lawyer. But for example, if I have an argument with, for example, madam, and she advised me, maybe what do you think if we prefer mediator like you? How can I be sure that you are not haven't a connection with?
But before you come to me, you probably will check me out. Right? You say, I go find Professor Leung, or I go find Professor Lee, or you won't go find somebody else.
Your answer is reputation.
Yeah, I think it's just the same as an arbitrator. Why you choose a particular arbitrator, or even a lawyer, or a professional? Why you choose that professional engineering firm?
Okay.
Because they have built up certain reputation.
I understand. Thank you. Thank you.
Yes.
Speak up, that's good.
Thank you for the talk. I think it's a good job.
Thank you.
Yeah. So if a student or a high schooler would like to be a mediator, what kind of subject he may choose, or what kind of school she or he would?
There are over 30 service providers in Hong Kong at the moment that provide courses on mediations. Okay, but as I said on one of my last slides, is that practice is a thing. Okay, and personally, I think experience in life is also important. Okay, will you, just like what this gentleman was saying, that will he choose a high school student to be his mediators? Okay, well, he will say that, okay, that particular case, I probably won't, because I don't think he has sufficient life experience, isn't it? So I think everything counts, okay? Every mediators, Hong Kong have 2,100 mediators at the moment in the list under Hong Kong Mile, okay? Out of the 2,000 people, why people choose me or versus somebody else? Okay, you have to build up your reputations and your background, your expertise. Some people may choose me to do construction because I have a construction background, or IT because I have an IT background. Some people may purposely choose me because of my reputation in mediation. So that means that the mediation skills is more important for the relevant cases. Okay, I do a lot of cases that's not within my own professions. Okay, like trading cases, shareholders disputes. You know, I didn't realize other industry make so much money. I should not be in my profession. After I did a case, I realized that wow, I should be in that profession instead. So I think parties look for different things. Okay, for high school students, after they are trained, they may be doing some pro bono work. If they are interested, they get, like I mentioned, the school mediations, right? There are more senior students doing mediation for lower grades students on their disputes in some of the high school now. Okay, under Family Welfare Association, they set up a school mediation scheme. Okay, and that's what they do. So it depends on the dispute itself. Okay?
Thank you. I think it's good to give training to like in the school area. So it seems like a mediator can come from all fields. Right?
Yes. Actually, out of the 2,100 mediators in Hong Kong now, they are qualified mediators. They come from all sectors. Okay. And I'll give you a hint, is that actually lawyers, the passing rate of lawyers are lower than other professions. Because they have been trained for 4 years, 3 years as an adversary, and then they probably practice under an adversary position. They have to fight the case, okay? So their mindset sometimes are more in the fighting mode than a social worker who is more into conflict resolutions.
Thank you.
More questions?
Okay?
Okay.
Thank you, Eric.
Thank you. Thanks a lot. There's some snacks over there still. You are hungry, please.